the Court for Nassau County, Florida versus the Chief Judge of the Fourth Judicial Circuit. Counsel for the petitioner may proceed whenever ready.
Thank you. May it please the Court, John Londot, on behalf of Honorable John Crawford, Clerk of the Court of Nassau County. I'd like to reserve 5 minutes of my time, if I may. Your Honors, the Clerk of the Circuit Court is the only person in Nassau County charged with ensuring that all expenditures of public money are done in accordance with law. He's the only one pursuant to the Florida Constitution and the Florida Supreme Court in Alachua v. Powers who bears personal responsibility, personal risk, if expenditures are not made in accordance with law. In that capacity, he had the occasion 3 times this year to assess whether expenditures were lawful pursuant to Section 939.185 Florida statutes. That section is a deal among Florida citizens enacted through the legislature. It says counties can collect an additional court cost in certain cases of $65 on the condition, they can enact an ordinance to collect that money, on the condition that they use it for 4 purposes. Those 4 purposes are juvenile alternative programs, law libraries, legal aid programs, and the one that we're here on today, innovations to supplement funding for the elements of the state court system. Each of those 4 buckets is to be applied 25% against the money collected under the statute and under the ordinance, which was enacted in Nassau County, and the money has been collected.
The statute says innovations as determined by the Chief Judge of the circuit, right?
Yes, sir.
So do I read that to mean that the Chief Judge is the one who gets to decide what is or is not an innovation?
That appears to be what the statute says. It either means that, or it means that the Chief Judge gets to decide what is the allocation among the approved programs that are listed in the Florida Supreme Court's Administrative Order 4 TAC 222. But either way, that language is the question here. The first order directing Mr. Crawford to spend this money said spend it on senior judges. And Mr. Crawford, as the auditor of these funds, assessed it against the statute and learned that senior judges are an express element of the state court system. Judges are an express element of the state court system listed in 29004 Florida statutes. That order went away after discussion of it, but it resurfaced as an order to pay magistrates. He had the same question and the same answer, and that order went away. Magistrates are an express element of the state court system. The third order, 2013-6, is the one we're here on today, and that says use that money for innovations to pay a mediator that was appointed in a pending family court case. He asked the same question, and the same answer is there. Mediators are an express element of the state court system funded by the state. They're listed in 29004 sub 11.
I guess where I start getting confused about that is you're right, they're part of the state court system in 29.004 8, and it says general magistrates, special magistrates, and hearing officers. And then I go to what the approved innovations are, and I see hearing officers. So in what sense are hearing officers both an element of the state court system and an innovation, and why can't that be so in this case?
Well, I think in the sense that the Supreme Court has said Small claims hearing officers would be an innovation. I think that's the hearing officer type that's listed in the approved program in the Florida Supreme Court order.
But doesn't the approved list also include staff attorneys and law clerks, and what's the difference there?
Staff attorneys, I mean, if you look at the programs that are listed there, staff attorneys are not a listed element of the state court system.
Well, let's take a step back. I mean, certainly the Supreme Court's order predated the 2010 statutory change, which vested exclusive authority in determining innovations in the Chief Judge of the Circuit, correct?
Yes, ma'am.
And is there any suggestion in the statute that the innovations under the statute are limited to the ones on the approved list that is submitted to the Chief Financial Officer? Is there any mention of the Chief Financial Officer in the statute?
There's not, other than it says that, you know, the expenditures must be reported on forms approved by the Supreme Court. There's not a mention of the Chief Financial Officer, I don't believe.
So is there actually an approval by the CFO?
Probably not. I would think that the way Mr. Crawford reads the statute is the Chief Judge could approve new innovations. I don't think it's an exclusive list in the Supreme Court order. And there's
But to be clear, this is not even an approved list. This is simply a reported list of innovations.
Correct. I think they refer to it as an approved list, but they don't say it's exclusive. They allow for, I think the Chief Judge could send up a request to add something to the list, and it gets added to the list.
Right. So is there any record evidence of anything ever being, quote, disapproved by the Chief Financial Officer on this reporting list, or by the Supreme Court for that matter?
I don't think there's any record evidence either way.
Right. So again, this seems to be more of a reporting requirement rather than an approval process.
Right. And we don't take the position that this is any kind of exclusive list. This shows the types of examples that are innovations. This shows that the Supreme Court is honoring the word innovation, as the Attorney General did in his opinion, that an innovation has to be something that departs from established practices and forms. There has to be change, novelty associated with it.
Wouldn't that necessarily depend on the size of a circuit? I mean, for example, in Miami-Dade County, they might have an innovative program that deals with mental health of a certain kind of juvenile offender. They wouldn't, in a million years, wouldn't have a program like that in Nassau County. So maybe something. I mean, I understand from reading the briefs that they don't very often have family magistrates in Nassau County. Is that correct?
I'm not sure if they have family magistrates. Nassau County has provided a record statement that they don't have a full-time mediation program, which would be presumably a community mediation program of the type contemplated in the Florida Supreme Court order.
Yeah, or mediators is the word I was looking for. But I mean, I guess what I'm saying is, why wouldn't it be more likely that something like this would fall within the definition of an innovation in a small county? I mean, it would be hard to make an argument that this is an innovation in Miami-Dade County, but maybe it is in Nassau County.
Well, I don't think that the definition, I mean, the word has to be given its plain and unambiguous meaning if that's available. It's interesting to note that the Attorney General in 2008, I believe, said, here's the apparent definition. It's not provided separately in the statute, but here's the apparent definition. And
again, that predates the 2010 amendment, which gives discretion to the Chief Judge. Is it your position that innovations cannot be elements of the state court system, because that seems to read out of the statute the term supplement?
Well, it's our position that it can't simply be an express element of the state court system.
So it would be better, for instance, for it not to be an element. So if the Chief Judge of the Circuit decided that they wanted to have a wellness program for employees, yoga, since that's not part of the state court system, would it be your position that that would be permissible as an innovation?
Possibly. I'd have to consider that, but it's certainly, at least that would not be an express element of the state court system to be paid for by the state.
So it's your position that the only innovations that may be funded are things that are not expressly part of the system?
Yes, ma'am.
Well, let me ask you a question about your burden here. I suppose you would concede that coming before the court as you are on a petition for writ of certiorari, you have a rather heavy burden to demonstrate the need for the court to quash this order.
Well, we have the burden to show that that there's a departure from the central requirement of law.
Right, and our Supreme Court has defined that as not merely a simple legal error. The court said there must be a violation of a clearly established principle of law that results in a miscarriage of justice.
Right.
So that's your burden. So let me ask you this. Is there any authority for or against on the merits what the Chief Judge did here? Any case?
No case law on this statute.
If there is no case, how can you argue that what he did is a violation of a clearly established principle of law?
Well, here's how. The Chief Judge's position, and you'll see it in the way the language of the statute was quoted in the three orders. The first two orders said, I've determined I can use this money in the specific innovation fund. I can use it to supplement state court funding for the state court system, left out the word innovation. When this issue was discussed in the third order, the word innovation is finally added, but the words as determined by the Chief Judge are underlined, which did come after the AG opinion and didn't change the definition of innovation. In fact, let's say adopted the definition. What the Chief Judge proposes is that he can determine with unfettered discretion what's an innovation, in spite of the unambiguous meaning of the word innovation. To allow that to stand is an essential departure from the requirements of law and a violation of clearly established principles of law. Namely, the legislature can't give unfettered discretion to a Chief Judge. The legislature can't give the judge the ability to delete that word from the statute any more than a judge can add a word to a statute.
Well, counsel, even if we agreed with your position on that element, what about the miscarriage of justice? What is the miscarriage of justice in this case?
Here's the miscarriage. This sets a precedent that the Chief Judge has a fund that he can dispose of at his whim as he sees fit. And nobody's challenging the usefulness of mediators.
But if that's what the statute says, shouldn't we say that's what the statute says? And if the legislature doesn't like it, then they'll say, we're going to amend the statute to say 25% of the amount collected shall be allocated to fund innovations to be determined by the clerk of the court, for example, or somebody else.
Oh, I don't.
I mean, in other words, you're making an argument that this could lead to some sort of mischief, and I get that argument. But on the other hand, it seems to be what the statute says. It's determined by the Chief Judge.
It does, but the statute can't give unfettered discretion.
If you read the other term to supplement state funding specifically for those elements required in Chapter 29.004 and 29.008, certainly there is, some circumcision of the Chief Judge's authority.
Right, and the main one is the use of the qualifying term innovation. And if that term is ignored, then the Chief Judge is writing law in violation of separation of powers. You can't rewrite the statute and then apply it. So it comes with qualifications on that discretion, namely, has to be used for an innovation. The plain meaning of that word has to be applied. Has to be reported on forms, et cetera. And a principle of law that is violated is the fact that Chief Judges can't amend statutes on their own and then apply them.
Mr. Londa, you're about 2 minutes
Yes,
into
sir.
the time you wanted to reserve. Now, you can use your time however you like.
Yes, sir.
I just wanted to remind you, in case you weren't looking at that.
Thank you, sir. The miscarriage is if this fund is applied, is given to the Chief Judge in an unfettered way, then it's now county money that's been collected pursuant to the promise of this statute. We will only collect this money if we apply it this way.
Isn't your burden, though, to show miscarriage of justice in this case that's before this court today?
Yes, ma'am.
And what is that miscarriage?
That miscarriage is application of this money against the express language of the statute and setting the precedent that this is now no longer county money. This is the Chief Judge's money. Do with as he sees fit. I'll reserve the rest of my time. Thank you.
May it please the court. I'm Steve Busey. I'm here with Chris Dix. Chris and I are with Smith, Halsey, and Busey in Jacksonville. We represent Donald R. Moran, the Chief Judge of the Fourth Judicial Circuit, in responding to this petition. At our council table with us is David Holman, who's the county attorney of Nassau County and the author of the amicus brief. He appears on behalf of the County Commission of Nassau County. I have three things I want to address. One is the statutory construction. Two is the constitutionality argument that was articulated in the brief but not argued now. And thirdly is whether or not this case today is an appropriate case for this court to exercise its certiorari jurisdiction and issue certiorari. Starting with the statutory construction, y'all in the discussion with the clerk's counsel have hit right on the issue. We're not reading innovation out of the statute. We recognize it has to be innovation. That is something new, novel, or different. What I think the petitioner is reading out of the statute is the other language of supplementing state court funding. This is not about an activity or a program, not about a law clerk or a hearing officer or a mediation. It's about sources of funding. And we're talking about an innovation in sources of funding for the state court system under 2004 or local requirements under 29.008. And what we have determined when Judge Foster needed a mediator in Nassau County to resolve a difficult child custody case in which the parties could not resolve it and had no funds, and there was no mediation program in Nassau County, he appointed a mediator and thought that these funds could be used to supplement state court funding of mediations. And doing so with county funds under 939 was novel or different, wasn't done before. So it is an innovation, and it's supplementary to state court funding of the mediation program. And y'all have observed that there is in the approved list of the Supreme Court staff attorneys, and you have law clerks as an element of the state court system. There's hearing officers, small claims hearing officers in the approved list of the Supreme Court, and in the statute definition of the state court system, there are hearing officers. So they're comparable functions, and yes, mediation, but it's the source of funding that's new and different.
And let me ask you the same question I asked counsel for the petitioner. Is this really an approved list at all?
No. It's a list of applications that have been reported in the past. And that's all it is, and you're correct about that. But it's an example of how broadly worded this could read, and it really underlines the argument that I'm making. It's not the function we're talking about, it's the source of funding. Supplement state court funding. And petitioner argues that the circuit court, the chief judge, should not have unfettered discretion. Judge Rowe, your answer to that was absolutely right. It's not unfettered. It's confined by the statute. He can't use it for a trip to Bimini. It has to be supplement state court funding for the state court system or local requirements.
So given the types of things that are on these lists, even if it's not an approved list, but some other kind of list, as long as it's part of the state court funding, the floodgates, do you think the floodgates are just sort of open, that chief judges can use this money basically however they wish?
No, I think the statute ought to be literally applied is to fund innovations, that is, novel or different ways to fund elements of the state court system or local counties' fundings of local requirements. That's the way the statute reads. Just read every word into it, and it satisfies that.
And counsel, is it your position that the Supreme Court's reporting requirement of the chief financial officer gives the chief financial officer an opportunity to audit expenditures? So, for instance, if there were a trip to Bimini, presumably the chief financial officer might have an opportunity under his constitutional and statutory authority to intervene.
Yes.
So there is a check in that sense, although it's not provided for in statute.
That's right. And I'll just address just briefly the constitutional argument. In this case, Judge Moran did not force the county against the constitutional requirement to fund elements of the state court system. In this case, Bob Foster, Judge Foster and Nassau County went to Mr. Holman and said, is this okay to use these county funds in this matter under this statute? And the county attorney said yes. And when there got to be a question about that, as raised by the clerk, the county commission, who owned these funds, voted to file an amicus curiae brief saying, we support this. And so there is no unconstitutionality forcing the county to do it. The county volitionally adopted the ordinance and has agreed to the use of the funds in this manner. And finally, as to whether or not this is an appropriate use of certiorari, and y'all have hit on this, an extraordinary remedy, not available as a matter of right, only in limited circumstances, requiring a showing of a departure from the clearly established principles of law, resulting in a miscarriage of justice. It's just, there's no showing of that here. There's no record of that here. What happened is we solved a difficult problem, a difficult case pending in Nassau County, a small county who couldn't afford this sort of thing. We used these funds as an innovative way in Nassau County of paying for that mediation. It advanced the cause of justice in the county. It advanced the mission of the court. The county commission, who money it belongs to, agrees with it. And this is a good result. It's a win-win for everybody, and there's no miscarriage of justice. And we suggest you should exercise your discretion and deny the writ.
Your Honors, the case law is clear that when an administrative order by a chief judge adds a word to a statute, it exceeds the chief judge's jurisdiction and authority, and the writ of certiorari is the proper venue for relief. In this case, we're simply saying the mirror image, deleting a word from the statute, shows that the administrative order exceeds its jurisdiction and provides for writ of certiorari as relief. It's hard to figure out how mediation, an established element of the state court system, can be an innovation on mediation, especially when there's a mechanism already there for the county to pay for mediation. In fact, there's a statute that says when it comes to mediation, the county can pay for it if it wants to. Ms. Crawford has never challenged the utility of this mediation or the fact that the county can pay for it. The only issue is, can the county be ordered to pay for it from this one bucket that expressly says, use this only for innovations? The statute essentially says, use it for innovations or don't levy this fee in court cases. So to your point, Judge Padovano, I'm not sure how mediation in Nassau County can be an innovation, but it would be garden variety element of the state court system in Miami-Dade. And again, it's worth noting that mediation is paid for by the state. If this receipt had gone up to the state, OSCA has given
Your point is mediation couldn't be regarded as an innovation anywhere. Even if it is never done, let's say, and the county's so small that it's just never done, once every 50 years.
Right.
It's just simply not an innovation, according to your argument.
Yes, sir. It might be necessary, and it might be that the county doesn't have the money, and that's a different statute. If they want to ask for an amendment of this statute to say, you know, in certain counties, let us use this money for other purposes, just to, as the Chief Judge first quoted, to supplement the state court system, that would be a different statute. Thank you, Your Honor.
All right, thank you, counsel. Thank you, counsel, for both parties and for all three parties. We'll be in recess.